The hearing that was supposed to be over. The bailiff called the case in a flat, mechanical voice, like he was announcing a parking violation, instead of the end of a man's life. The sound echoed through the courtroom, dull and final. My sister stood up before the name was even finished. Not out of respect, not out of grief, out of hunger. She wore a cream-colored coat tailored so perfectly it looked expensive without trying. The kind of outfit that silently tells people you're competent, trustworthy, and already winning. Her hair was flawless, her makeup understated, her eyes completely dry. When she looked at me, there was no sadness there, only math. Her attorney moved next, smooth, controlled, wearing confidence like it was part of the suit. He approached the table and slid a thin stack of papers forward with 2 fingers, gentle and precise, like a blade being set down carefully. Your Honor, he said, voice calm and rehearsed. We move for immediate transfer of the estate to my client, effective today. Behind him, my parents nodded in perfect synchronization. My mother folded her hands like she was attending church. My father stared straight ahead, jaw tight, as if this were a quarterly review and I was an underperforming department. The judge didn't look at them. He looked at me. Ms. Vale? He said evenly. Do you object? My sister's lips twitched. She was waiting for me to fold. Waiting for the moment I'd always played in our family, the quiet one, the accommodating one. I didn't give her that. I straightened in my chair, placed my hands flat on the table, and made sure my voice didn't shake. Yes, I said. I object. Her attorney smiled, thin and polite. On what grounds? I didn't answer him. Not yet. I said. I'd like to wait until the last person arrives. The courtroom stilled. The judge blinked. The last person? He repeated. I nodded once. Yes, Your Honor? A sharp laugh escaped my sister before she could stop it. This is ridiculous, she said. There is no one else. My father finally turned toward me, just slightly. The way he used to when I was 16 and embarrassing him in public. You always do this, he muttered. The judge leaned back, adjusting his glasses. Ms. Vale, he said, patience thinning, this is probate court, not a performance. If you have an objection, it needs to be legal. It is, I replied calmly. But it isn't mine to explain. Her attorney stepped closer, tone smooth. Your Honor, we're requesting emergency appointment because the respondent has been uncooperative. There are assets that need immediate protection, and my client is the responsible party. Responsible. That word had always meant the same thing in my family. Give us control. Stop asking questions. My mother sighed softly. She's grieving, she told the judge. She doesn't understand how these things work. My sister kept her eyes on me, bright and cold. I'm just trying to keep everything from falling apart, she said. Grandpa would have wanted it handled properly. The judge flipped a page. This petition requests full authority over the estate, he said. It alleges the respondent is unfit and may interfere. Her attorney nodded. Correct. And you're asking me to grant that today? The judge asked. Yes, Your Honor. The judge looked back at me. Ms. Vale, what is your objection? I took a slow breath. They're asking you to act without the full record. There is no hidden record. My sister snapped. He's dead. This is how this works, Miss Vale. The judge said sharply, to her, this time, you will not speak out of turn. Her smile tightened. Her attorney tried to recover. If Miss Vale wants to delay, we object. The estate can't wait. It won't be a delay, I said, meeting the judge's eyes. It'll be minutes. The judge exhaled once, clearly deciding whether I was worth the trouble. Then he glanced toward the courtroom doors. Who are we waiting for? He asked. I answered with the simplest truth I had. The person who actually controls the inheritance. For the first time, my sister's confidence cracked. That's me, she said automatically, then stopped when the judge's gaze snapped to her. Before anyone could speak again, the courtroom doors opened, not dramatically, just a firm, controlled push. A man stepped inside wearing a plain black suit. No jewelry, no expression, just an envelope in his hand, and the calm of someone who didn't care who in the room had money. He walked straight to the clerk's desk and said one thing. My name is for the record, he said evenly, and this is for the court, from the trustee. The judge reached for his glasses again, and everything my family thought they controlled shifted. The judge hadn't even opened the envelope yet, but my sister's face already knew something was wrong, because whatever was inside hadn't come from family, and banks don't make emotional mistakes. The envelope that changed the room. The judge didn't open the envelope right away. He turned it once in his hands, studying the return address, as if it might rearrange itself if he looked long enough. The paper was heavier than normal mail. Thicker. Official in a way my family's confidence suddenly wasn't. The man in the black suit stood quietly beside the clerk, hands folded, posture neutral. He wasn't here to argue. He wasn't here to impress anyone. He was here because something had already been decided, long before this hearing. The judge finally tore the envelope open. No drama, just a clean rip. The sound seemed louder than it should have been. He removed the first document, eyes scanning the header. His jaw tightened almost imperceptibly. Hawthorne National Bank, he read aloud. Trust Department. My sister's expression flickered, just for half a second, before she rebuilt it. She'd built her entire identity around being the one who handled money. Hearing a bank named in open court should have made her look powerful. Instead, it made her look exposed. The judge continued reading. This is a notice of trust administration, he said. It states that the decedent's assets were placed into a revocable trust, which became irrevocable upon death. Her attorney shot to his feet. Your Honor, we're in probate? Sit down, the judge said without looking up. The attorney froze, then lowered himself back into the chair. The judge turned another page. This document identifies the successor trustee. He paused, longer this time, then he read it aloud. Successor trustee Hawthorne National Bank Trust Department. The room shifted. My parents stiffened. They hadn't been aiming for fairness. They'd been aiming for control, and a bank doesn't care about control the way families do. A bank cares about compliance, documentation, and risk. Her attorney tried to regain footing. Even if there is a trust, probate still has jurisdiction. Counsel. The judge interrupted. Your motion requested immediate transfer of all inheritance to your client. He tapped the paper once with his finger. This trust certification states that the probate estate is minimal. The bulk of the assets are held in trust. He looked to the clerk. Mark this as received. Then he turned to my sister, not as a sibling, not as family, but as a petitioner who had just overreached. Ms. Vale. He asked. Were you aware that your grandfather established a trust with a corporate trustee? She lifted her chin. He was influenced, she said quickly. He didn't understand what he was signing. The judge didn't debate her feelings. He simply held up another page. This includes a capacity affidavit, he said, witness signatures, and an attorney's certification confirming execution with full competence. My father's jaw ticked. My mother's eyes narrowed as she recalculated. Then the judge reached the line that changed the temperature in the room. He read it silently first, then out loud. Note contest clause. Every sound disappeared. Any beneficiary who attempts to seize trust assets contrary to the trust's terms forfeits their distribution. Her attorney's face drained of color. My sister's eyes widened just slightly, then narrowed, as if intimidation might still work on ink and paper. The judge looked up. Counsel, he said, you filed a motion today demanding immediate transfer of all inheritance. Yes, the attorney said carefully. You understand, the judge replied, that this filing may have already triggered forfeiture under this clause. Silence. We dispute the validity. The attorney finally said, you're welcome to dispute it. The judge replied, but you don't get to pretend it isn't there. Then he turned to me. Ms. Vale, he said, you asked to wait for the last person to arrive. Was this the person? Yes. I answered, pulse loud in my ears. The trustee controls distribution? The man in black spoke for the first time. Your Honor, he said calmly. I'm not here to argue. I'm here to deliver notice and confirm the trustee's position. The judge gestured once. Proceed? The trustee does not recognize the petitioner's request. The man said. No assets will be distributed based on today's motion. The trust will be administered strictly according to its terms. My sister shot to her feet. You can't just sit down, the judge snapped. Her breathing changed. Faster, thinner. Her attorney stood again, desperate now. At minimum, Your Honor, we move to compel production of the full trust. We question whether there was undue influence. The judge's eyes hardened. Undue influence is a serious allegation, he said, and you're making it without evidence. My sister leaned forward. Witnesses, she said, gesturing behind her. Two relatives stood awkwardly at the back, eyes darting, unsure whether they'd just been promoted or sacrificed. The judge looked unimpressed. Witnesses testify to facts, he said, not feelings. Then he turned back to the man in black. Does the trustee have any documentation addressing concerns of coercion or abuse? The judge asked. Yes. The man replied without hesitation. A written statement, prepared in advance. My sister's head snapped up. What statement? The judge extended his hand. Provide it. The man reached into a second envelope, thin, unmarked, and passed it forward. The judge opened it, and as his eyes moved across the page, his expression changed, not to shock, but to recognition. He looked up at me. Ms. Vale, he said slowly. Did you know your grandfather anticipated today? I swallowed. He told me he prepared something, I said. I didn't know what it said. The judge nodded once. Then he began to read. The first line of my grandfather's statement made my mother gasp, and my sister go completely still. Because it didn't defend me. The statement he left behind. The judge didn't read the entire letter out loud. He didn't need to. He read just enough to make the record undeniable, and the room unlivable. If you are hearing this in court, he began, voice steady, it means members of my family have attempted to take control of my estate by accusing my granddaughter. My mother made a sound like the air had been knocked out of her. Not a sob. Not grief, shock. The judge continued. He read how my grandfather had asked me to move in after his fall, how he insisted on meeting with his attorney alone, how he created the trust because he feared pressure, rushed signatures, and manufactured emergencies. Then the judge reached the line that changed everything. On the night I contacted emergency services, he read, my son arrived with a mobile notary and demanded I sign new documents. I refused. I requested witnesses. If these actions are later described as elder abuse, they are a projection of their own conduct. The courtroom went silent. No whispers, no shifting chairs. My sister didn't blink. My father's face had gone rigid, like a mask glued on too tightly. This statement, the judge said, setting the page down, is consistent with the dispatch audio already entered into the record. My sister's attorney stood slowly. Your Honor, we object. This is hearsay. It's a statement of intent, the judge replied, and it directly addresses the allegations raised today. He looked at my sister. You accused the respondent of elder abuse. You did so without presenting medical records, prior complaints, or any contemporaneous evidence. She isolated him, my mother said quickly. She turned him against us. The judge looked at her once. Just once, ma'am. He said, this is not family therapy. Then he turned back to the man in black. Does the trustee have any independent concerns regarding abuse or coercion? The judge asked. No, Your Honor. The man replied. The destinant met privately with counsel. He confirmed intent. He provided documentation. The trustee found no irregularities. My sister leaned forward, voice sharp. He was confused. The judge lifted the trust certification. Confusion doesn't look like this, he said. This is formalized intent. Her attorney tried again, weaker this time. We would request discovery. Discovery is not a fishing expedition. The judge replied. You don't accuse someone of elder abuse in open court as leverage. My sister's face flushed. It's not leverage. Then bring evidence, the judge said. Not relatives with opinions. For a moment, no one spoke. Then my sister did something reckless. Your Honor, she said loudly, standing again. We're not the only ones who can tell this story. The judge's eyes narrowed. What story? She turned toward me. She controlled his finances, his phone, his visitors. Her attorney didn't stop her this time. Those are allegations. The judge said. Do you have proof? She hesitated just a fraction too long. Would need time. Her attorney said carefully. The judge leaned back. Time doesn't fix a bad filing. He turned to the clerk. Dismiss the motion. My sister's head snapped up. What? Motion denied. The judge said. And I'm setting a hearing on sanctions. My mother's face drained of color. My father clenched his fists. You can't do that. My sister said. She gets everything. The trust gets administered according to its terms. The judge replied. No one gets anything today. The man in black spoke again. The trustee will suspend any distributions to parties who triggered the no contest clause pending review. Suspend, my sister hissed. That's not, that is, he said simply. The judge looked at her, voice colder now. Mems Vale, you entered this courtroom assuming authority you did not have. You will leave without it. Her eyes burned into me. This wasn't about money anymore. It was about exposure. Then the bailiff stepped closer to the judge and whispered something low. The judge's expression shifted, not to surprise, but to confirmation. He nodded once. Then he looked directly at my father. Mr. Vale, he said, remain seated. My father stiffened. Why? Because, the judge replied evenly, there's a deputy in the hallway with paperwork for you, and it's not from this court. The courtroom doors opened again. A uniformed deputy entered, holding a document with a bold header. Sir, the deputy said to my father, you've been served. My father's hand shook as he took the papers. He scanned the first page and froze. This wasn't probate. This was criminal. The judge watched him read. This court has nothing to do with that paperwork, he said, but you are still under oath. My father swallowed hard. This is harassment, my mother whispered. You protected yourselves into a referral, the judge replied. 2 more deputies appeared near the doors, not moving in, just present. My sister's attorney cleared his throat. Your Honor, we request a recess to confer. You may confer, the judge said. But the damage is done. He turned to the man in black. Does the trustee request a protective order? Yes, Your Honor, he replied. prohibiting interference and harassment of the primary beneficiary. My sister scoffed. Harassment. The judge looked at her. You accuse someone of elder abuse without evidence. You don't get to scoff. Granted, he said. Draft it, I'll sign today. The gavel came down. Court is adjourned. I thought the hearing was over. I thought the worst had already happened. Then my lawyer's phone vibrated, and the alert on the screen told us someone was trying to access the trust right now. The attempt that came too late. We were barely outside the courthouse when my attorney stopped walking. He stared at his phone like it had just insulted him. That was fast, he said quietly. What? I asked. He turned the screen toward me. Security alert. Hawthorne National Bank Trust Department. Attempted access blocked. My stomach dropped. The hearing had ended less than 5 minutes ago. They're doing it now, he said. Someone's trying to get into the trust. Behind us, the courthouse doors swung open and shut as people spilled onto the steps, lawyers, clerks, families finishing their own private disasters. Somewhere inside, my parents were probably still pretending this wasn't real. But someone had already moved. My attorney didn't hesitate. He called the number attached to the alert while we were still standing at the curb. Hawthorne Trust. A woman answered, voice calm, professional. This line is recorded. This is counsel for the primary beneficiary, he said. We just received a security alert. I need details. A brief pause. Keyboard clicks. Yes, she said. There was an attempted login to the beneficiary portal. It failed multi-factor authentication. Immediately after, there was an attempt to change the contact phone number on file. I felt cold all over. Change it to whose number? I asked. She didn't answer me directly. Do you authorize disclosure to your client? Yes. My attorney said instantly. The attempted change request originated from a device associated with the petitioner, she said. Alyssa Vale. I closed my eyes. In the courtroom, she hadn't turned her phone face down out of shame. She'd done it to work. Did she authenticate? My attorney asked. No. The trust officer replied. The system blocked the request. A manual fraud flag has been placed. Distribution status is now set to hold pending review. Good, he said. Freeze everything. No changes phone, email address, without in-person verification. Already done, she replied. A report has been generated. Send it to my office, he said, and note the protective order issued today. Understood. The call ended. The city noise rushed back in. Too loud, too normal. She just created a record. My attorney said quietly, and it's time-stamped minutes after court adjourned. We drove straight to his office. No victory lap. No confrontation. Just damage control. I signed a single-page instruction, all trust communications routed through counsel, no direct family contact accepted, and any attempted access treated as fraud. He forwarded the bank's security report to the court clerk with a short note. Attempted access blocked within minutes of recess. Nothing dramatic. Just evidence. An hour later, his assistant stepped in. The trustee wants to speak with you. The video screen lit up. The same man in the black suit appeared. Same neutral posture. Same controlled tone. Ms. Vale, he said. I wanted it very clear. I didn't interrupt. The trust will distribute only according to its terms. He continued. There will be no exceptions due to family pressure, no advances, no temporary transfers. He glanced down at a note. Due to today's filing and the attempted portal interference, the trustee has formally determined that Alyssa Vale has triggered the no contest clause. My breath caught. Her distribution is now forfeited. Pending court confirmation. I hadn't expected it to land that hard, even knowing it was possible. My attorney asked. And the parents? The trustee's expression didn't change. Grant and Linda Vale's contingent interests are under review, he said. Given their coordination in the petition, the trustee is treating their involvement as interference. He paused. A declaration will be filed with the court. When the call ended, the room felt smaller, not because of fear, because of finality. 2 weeks later, the sanctions hearing was brief. My sister's attorney avoided eye contact. He stood, cleared his throat, and said, Your Honor, we withdraw all contested claims and apologize to the court. The judge didn't smile. He imposed sanctions for bad faith filing, ordered payment of attorney's fees, and entered an order acknowledging the trustee's enforcement of the no contest clause. Then he looked directly at my parents. You were not denied anything, he said. You attempted to take control, and were stopped by documentation. My mother cried then, real tears this time. My father stared at the floor. There was no loophole left. Within the month, Hawthorne National Bank executed the first formal distribution under the trust terms. The house remained protected. Assets moved with receipts, confirmations, and a paper trail my family couldn't rewrite. My sister's confidence didn't protect her from a clause she'd ignored. Because courts don't reward confidence. They reward records. I thought that was the end. Then my attorney forwarded me one last document, filed quietly by the trustee, that explained why my grandfather planned this so carefully, and what he feared my family would do after he was gone. The record he knew would survive them. The final document didn't arrive with drama, no alerts, no emergency calls, just a quiet email from the trustee's office with a single attachment and a short line of text, filed with the court this morning. For your records. I opened it alone at my kitchen table. It was titled simply Declaration of Intent. My grandfather had written it years before he died, not as a goodbye, not as a defense, as a prediction. The declaration explained why he chose a corporate trustee instead of family. He wrote that he had watched entitlement grow louder than affection, urgency replace patience, and paperwork become a weapon. He described being rushed, pressured, told that things needed to be handled quickly. For his own good, he wrote that he feared false narratives more than open conflict. I am not confused. One line read, I am cautious. The document detailed his meetings with counsel, the safeguards he insisted on, and the reason the no contest clause was written so sharply. If anyone challenges this trust, he wrote, it will not be because they are harmed, it will be because they are angry they cannot control it. I closed the file and sat there for a long time. 2 weeks later, the court accepted the trustee's declaration without modification, no arguments, no appeals, just confirmation. The no contest clause was enforced. My sister's forfeiture became permanent. My parents' request for a family settlement was denied, along with an order requiring them to reimburse legal fees tied to the false filing. Within 30 days, the trust completed its first distribution exactly as written. The property remained outside probate. Assets were transferred with signatures, timestamps, and receipts that told the same story no matter who read them. The fighting stopped, not because anyone made peace, because there was nothing left to fight with. I didn't hear from my sister again. Not directly. I heard through silence, through the way her name stopped coming up, through mutual acquaintances suddenly careful with their words, through the absence of threats that once arrived so confidently. My parents tried once, a carefully worded message. Apologies without ownership, language shaped like reconciliation but hollow underneath. My attorney advised against responding, so I didn't. What surprised me most wasn't the outcome, it was how calm everything felt afterward. I had spent years bracing for confrontation, for emotional ambushes, for last-minute reversals. Instead, the end came quietly, through procedure, through forms, through systems that don't flinch. One evening, months later, I opened the folder my grandfather had left behind. Not legal documents this time, notes, handwritten. He'd written about why people confuse confidence with authority, why bullies assume volume will fill gaps in evidence, why families are often the most dangerous place for entitlement to hide, and then the last page. If they ever tell you that you took something from them. He wrote, remember this, nothing was taken, control was simply refused. That line stayed with me, because it reframed everything. I hadn't won. I had been protected. The trust didn't punish my family, it limited their reach. And that's the difference between revenge and planning. Weeks after the final distribution, the trustee sent one last notice. All restrictions remained in place. No changes without in-person verification. No exceptions. No informal requests. Locked. Logged. Done. I stood in the house my grandfather loved. The one he'd refused to sign away under pressure. And realized something important. People who rely on intimidation never plan for systems that don't care about their emotions. Banks don't argue. Courts don't remember stories, only records. And families that confuse entitlement with inheritance eventually collide with both. If there was a lesson in all of this, it wasn't about money. It was about proof. When someone tries to erase you with a story, you don't fight story with story. You let the record speak. Most people think inheritance battles are won by the loudest voice in the room. They're not. They're won by the person who planned quietly, before anyone knew there would be a fight.